Nothing can be more fun than going out on the water in your boat. Nothing can ruin that fun faster than being boarded and being arrested for drinking while boating. A question we commonly get is, can law enforcement come on board my boat and investigate whether I'm drinking? The short answer is yes, they can. If they have reasonable articulable suspicion that there's drinking and boating going on, they can come on your boat. But also, they have many other excuses to get on your boat, such as a safety check, equipment check, things along those lines that they can board a boat at any time. In Virginia, the Commonwealth has to prove the same elements for operation of a watercraft as they do for the operation of a motor vehicle. These are essentially two: that you are operating that watercraft and that you are under the influence of an intoxicant, which is typically alcohol, but can include other drugs or a combination of those drugs. To break this down further, if you are operating your watercraft and you are boarded by law enforcement and they discovered that there's alcohol on board and that you have been drinking, there's a very high likelihood that an investigation will ensue. And in that investigation, they were probably going to ask you to do some type of field sobriety test. These are voluntary. You do not have to participate if you do not wish. If during the investigation this law enforcement officer determines that he or she has probable cause to arrest, then they will ask you to take a blood or breath test. An unreasonable refusal to provide a blood or breath test can and will trigger an additional charge of refusal, which will have separate penalties. The penalties for operating a watercraft while under the influence are essentially the same as operating a motor vehicle under the influence. A Class 1 misdemeanor, which is maximum punishment up to 12 months in jail, $2,500 fine, and loss of your boating privilege for 12 months. You also have to attend ASAP, the Alcohol Safety Action Program, and you'd have to take a boater safety course. Now, the penalty for refusal to take a blood or breath test would be the 12-month suspension of your boater's privilege. Another question we often get in this area is firearms on my boat. Virginia is an open carry state, so there is no permit required if you're going to open carry on your boat. If you're going to concealed handgun carry, utilizing your concealed handgun permit, you need to have the permit with you as well as appropriate ID, and it needs to be presented to law enforcement upon request. If you're going to carry your handgun concealed pursuant to the concealed handgun permit, you need to be aware that if you are carrying that while under the influence of alcohol or drugs, that's a Class 1 misdemeanor in Virginia, punishable by up to 12 months in jail and a $2,500 fine. An additional penalty is that your concealed handgun permit is revoked and you're not eligible to apply for another handgun permit for 5 years. And finally, for those of you that do not have a concealed handgun permit and you do not want to open carry on your boat, but you do want to bring your handgun, you can secure that handgun in a container or compartment on the boat.